let's ask a pretty simple question. Should you have to pay for work that's already been done? Seems obvious, right? Well, this explainer is all about what happens when a system designed to care for people seems to forget the answer.
So here's the story. We're looking at a case where public funds, taxpayer money meant for a high-needs individual, just evaporated. We're going to follow what happens when the people providing the care are suddenly left to foot the entire bill themselves. So here's the setup. You have a home-sharing provider, a caregiver, looking after a client with very high needs. One day, the public funding for that care just disappears. Poof. And just like that, the provider is covering every single cost out of their own pocket.
And we're not talking about a week or two. For 139 straight days, round-the-clock care was provided with zero payment, not a single dollar. That, as you can imagine, creates a massive financial black hole for the caregivers.
And look, this is really important. We're not just talking about unpaid time or salary. These are hard, tangible costs. We're talking about a roof over someone's head, food on their plate, transportation, medicine, all the essentials for daily life. All of it paid for directly by the provider.
Now, before any lawyers got involved, the caregivers tried to sort this out directly. They went to the agency that was overseeing the care, a nonprofit called IFRC. But those conversations, they went absolutely nowhere. So a formal claim became the only path forward.
So what do you do? Well, the caregivers took the next logical step. They filed a claim in small claims court, not to get rich, but just to recover the money they were out.
And so, on July 8, 2024, it became official. The case was filed in British Columbia's Small Claims Court, a venue that's literally designed for these exact kinds of disputes.
Now, this is maybe the single most important point of the whole situation. This lawsuit was not about a salary. It wasn't about penalties or damages. It was a claim for reimbursement, a simple request to be paid back for the actual money they had already spent during those 139 days. They were just trying to fill that financial black hole.
But you might be wondering, why sue IFRC, the nonprofit agency, and not the main government funder, CLBC? Well, it's because IFRC is a separate organization. They were the ones on the ground, giving the day-to-day instructions and overseeing the care directly. Legally, that made them the logical party to file the claim against.
And this is where the story takes a really dramatic turn. Because in response to this very reasonable claim for expenses, the agency didn't just defend itself. Oh no, it launched a counterstrike.
And this visual just says it all, doesn't it? On one side, you have the caregiver's simple claim for those 139 unpaid days, and on the other, you have the sheer scale of the agency's response. The difference is just, wow.
Yep, just 2 weeks after that initial claim was filed, IFRC hit back. They filed a counterclaim demanding that the caregivers, the very people who had provided all that unpaid care, pay for all of the agency's filing fees and all of its legal fees.
But it didn't stop there. The counterclaim also had this little gem attached, an itemized bill for $2,288. And what was it for? To cover the future travel expenses for one of their directors to attend a court date. We're talking airfare, a hotel, a rental car, the whole shebang.
And here is the absolute kicker. The agency's office is literally a 10-minute drive from the courthouse. And to top it off, in the year and a half this dispute has been going on, not a single person from the agency has ever shown up in person. They only join online. So what on earth is this travel bill for?
So what was the agency's official argument here? How did they justify this? Let's try to break down the logic, or lack thereof, behind their defense.
Okay, so IFRC's main defense was basically, hey, it's not our fault. They argued that once the main government body, CLBC, ended the contract, IFRC was off the hook. In short, they pointed the finger directly at CLBC.
But this is where things get, well, contradictory. On paper, in their written defense, IFRC says the whole problem is CLBC's responsibility. But then, in court, when they had the chance to actually bring CLBC into the case as a third party, they officially refused.
It just begs the question, right? If you are so confident that someone else is to blame, why would you be afraid to say that formally in front of a judge and make them a part of the case? It doesn't quite add up.
So now you have this complete mess. A claim for expenses, a massive counterclaim, and a defendant that's blaming an organization that isn't even part of the lawsuit. At this point, the court had to step in.
So let's just walk through that again. July 8th, the claim is filed. Just 2 weeks later, the wild counterclaim lands. Then, months go by, and finally, on February 5th of the next year, the court makes its move.
The judge basically looked at all this and said, hold on a second. They determined that there was no way to get a fair decision without having the main public payer, CLBC, involved in the case. Their presence was essential. And here is the final, almost unbelievable twist in this story. The court ordered CLBC to be added to the lawsuit, but the complex procedural legal work required to do that, the very work the agency refused to do, was assigned to the caregivers, the same people who had already provided 139 days of unpaid care.
Let's just step back from this one case for a moment, because what happened here seems to shine a pretty bright light on a potential flaw in the entire system of care, risk, and who is truly responsible.
Ultimately, it leaves us with some really tough questions. What does it say about a system when a family that provides months of unpaid care is met with a massive counterclaim? Who is actually being protected in that scenario, and who's being left vulnerable? And maybe the most important question of all, if this can happen once, what's to stop it from happening all over again to another provider with another client somewhere down the line?